Are you navigating the complex world of U.S. immigration? Need answers to your K-1 Fiancé Visa questions for 2024? Well, you're in the right place. Welcome to Direct U.S. Immigration's channel, where you get direct access to our most up-to-date immigration and global mobility space. I'm an immigration attorney with almost a decade's worth of experience, and today we're going to talk about K-1 Fiancé Visa frequently asked questions for 2024. Stay tuned. Thanks for tuning in. My name is Maitreya Brown, and I'm a U.S. immigration attorney based in Washington, D.C. I'm also the principal attorney at Direct U.S. Immigration, where we work with clients in all 50 states and around the world. Before we start, click on the like and subscribe button to follow our Immigration Hub to get the latest immigration information that could be vital to your case. And also, be sure to stick around until the end to get a bonus tip on what you can do if your K-1 Fiancé Visa is denied and which visa is most appropriate for you. Now, before we start, keep in mind that immigration laws and procedures may change, so it's essential to consult the latest information from official sources or legal professionals. Now, here are the K-1 Fiancé Visa frequently asked questions. So, what is a K-1 Fiancé Visa? So, the K-1 Fiancé Visa is a non-immigrant visa granted to the foreign fiancé of a U.S. citizen to allow him or her to enter the U.S. for the sole purpose of marrying the U.S. citizen within 90 days of his or her entry on American soil. Now, do I need a lawyer for a K-1 visa? So, no law in the U.S. requires you to use an attorney to file that K-1 visa application. However, the main cause of delay and denial in K-1 visa applications is inaccurate and poorly prepared applications. When you hire an immigration attorney to represent you, you significantly decrease the strain and insecurity you experience as you go through the process. Now, another question is, can I get a K-1 visa if I have had some criminal history in my home country? So, criminal history can become a serious obstacle to immigration to the U.S. However, it does depend on the severity of the crimes committed. These crimes would need to be expertly examined to determine the likelihood of your ability to immigrate to the U.S. So, for example, if you have a felony on your record or its equivalent, it may be more difficult to enter the U.S. Now, you say, what if my U.S. citizen fiancé has a criminal record? So the type and seriousness of the criminal record, whether it's arrests or convictions, will determine whether your partner can file a fiancé petition on your behalf. So in some instances, such as convictions of kidnapping, solicitation to engage in sexual conduct, and possession of child pornography can either bar you from filing a K-visa case, or in some instances, a waiver must be filed to allow the filing. It is important to reveal this information to our law firm when you consult with us so we can properly assess whether that K-1 visa is the most viable option for you. Now, another question is, what if my fiancé has children? Can they immigrate with him or her? So if the foreign fiancé has unmarried children under the age of 21 living with them abroad, they may be eligible for K-2 visas to enter the U.S. with their parent. They must be included in the original petition to USCIS and must travel at the same time or after the K-1 visa holder. Now, what does a K-1 visa medical examination involve? So every applicant must undergo a full medical examination by an authorized medical physician. The medical examination will include a review of the applicant's medical history, physical examination, chest X-ray, and blood tests. The physical examination will at least include examining the eyes, ears, nose and throat, extremities, heart, lungs, abdomen, lymph nodes, skin, and external genitalia. There are several steps involved in seeking a medical examination. The doctor that carries out the test must be permitted to do examinations for immigration purposes, and you must inform the doctor that the medical test is for immigration purposes. At this step, you will incur separate costs for the medical exam. Now, another question is, can I work with a K-1 visa? So yes, but you must apply for work authorization by filing Form I-765, which again is that application for employment authorization before you can work. So like the K-1 visa, the employment authorization is only for 90 days, starting from the day you arrive in the U.S. So applying for this work permit is generally not recommended because the processing time for USCIS to make a decision on the application compared to the K-1 visa that expires after 90 days may only allot the visa holder a small window to work on that work permit, if any. Now, if you choose to apply for permanent residency after you arrive and file Form I-45, which is that application to register permanent resident status or adjust status, you can include Form I-765 with your application. And this would grant you work authorization for a much longer period, which you may extend until a decision is made on the green card application. Now, another question is, how long is the Fiancé visa valid for? So a K-1 visa is valid for a period of 6 months, and this means that the foreign fiancé can travel to the U.S. within 6 months from when the visa is issued. However, once they've entered the U.S., they can only remain for 90 days. If they are not married to that K-1 U.S. citizen sponsor within that time frame, the foreign fiancé must exit the U.S. Now let's talk about what happens if we don't marry within 90 days. So suppose you fail to get married within 90 days. In that case, the foreign fiancé and any children included in the original petition, again, must leave the U.S. Failure to depart violates U.S. immigration law and can lead to deportation. Any future eligibility for U.S. immigration benefits may also be negatively affected. It is important to note that the K-1 visa holder may only apply for a green card based on their marriage to the petitioner, though other options may be available if they are married after the 90 days. We could discuss that later. Now, the next question is, if my partner is a green card holder, not a U.S. citizen, can I still apply for the K-1 visa? So the K-1 visa is only open to the fiancés of U.S. citizens. If your partner is a green card holder, they will only be able to petition you for your entry if you are already married, or if your green card holder partner is eligible for citizenship. I recommend applying and obtaining U.S. citizenship before utilizing the K-1 visa option. Now, how do you apply for a green card after you've entered the U.S. With a K-1 visa? So suppose you have entered the U.S. on a K-1 visa and are married to your partner. Congratulations on starting your new life together. To apply for your green card, you must file Form I-45. And with this application, I also recommend filing Form I-765 and Form I-131 for work and travel authorization. Now, another question is, do I need an affidavit of support for the K-1 visa? And the answer is yes. You will need to submit Form I-134 when applying for that K-1 visa at the embassy. Now, what is the difference between the K-1 visa and the K-3 visa? So if you are the fiancé of a U.S. citizen, you can apply for the K-1 visa. If you are the spouse of a U.S. citizen, you can apply for the K-3 visa. Both visas are available only to partners of U.S. citizens and not green card holders. Now, another question is, why would a K-1 visa be denied? So some activities may make you ineligible for a visa. Examples of these ineligibilities include drug trafficking or submitting fraudulent documents. Again, fraudulent documents can include false dates of birth, false financial records, etc. So, as promised, here's some bonus information that you may not know about. So, in case of denial of Form I-129F, which is that first stage, in many cases, you may be able to file one of the two legal motions to have your case reviewed a second time. And the first is a motion to reopen. Now, this is used when new documentation or evidence has come to light that may change the outcome of the fiancé visa case should it be reopened. And the second is a motion to reconsider. And this is used when you or your immigration attorney believes that the evaluating officer was incorrect in his or her legal decision. Now, you can demonstrate this through a legal argument. Now, because they require legal expertise and arguments, neither of these routes should be taken without having an immigration attorney to assist you. And this is the best way to successfully overturn a fiancé visa denial. Now, last but not least, be sure to check out the caption below this video. We've got questionnaires for different types of visas so that we can help you determine which visa is most appropriate for you. And if you're traveling soon, we also have a list of some of my travel favorites. So I hope you found this video helpful. Subscribe if this content or information helps you in any way. Comment below if you want me to talk about something in specific, and share this resource widely because you never know who needs answers to these questions. Additionally, if you have any specific questions about this video as they pertain to your unique circumstances, please schedule a consultation with us, also at the link below, and I'll see you in the next video.